Welcome to today's webinar, Solving the GDPR's 10 Toughest Problems. Presenter Scott Giordano. He is an industry-leading data privacy attorney. So welcome, Scott, and I'll go ahead and hand the webinar over to you.
Fabulous, Doug. Thanks for having me on board again. So first up, first of the GDPR's 10 toughest problems is locating all of your organization's personal data and mapping it. Fabulous. Okay, so slide number one, problem number one, creating a data inventory. And so when we talk about data inventory, we're talking about the Article 30 record of processing activities. So that's the first one, and it's also the first problem I tackle when I work with clients.
So how are people doing data inventories now, today?
What they're doing now, Doug, is they are conducting interviews. So they'll conduct interviews with the person responsible for the application itself. So that could be, for example, an Oracle database or Workday. It could be a homebrew database. It could be a CRM tool. It could be anything. And interviewing the business owner or the technical owner and asking them what kinds of personal data are involved here, and is it special personal data? Who has access to it? How's it being protected? There's a laundry list of questions that you have to ask to create a really effective data inventory. And so the problem, if not the challenge with this, is that as of now, it tends to rely almost exclusively on interviews with process owners. And the problem is that there's, in many cases, if not all, where there's data that the process owner doesn't know is being processed, doesn't know where it's being stored, doesn't even know if it's on the network. And this is a consistent phenomenon I observe whenever I work with our clients, is that almost every case you're finding data that you didn't know existed. And so it's a big challenge, because if you don't know where the data is, you can't protect it. You can't certainly notify people correctly that, hey, we're using your data. We'd like consent to use it. So this is a big issue. And as a consequence, one of the things that I started doing probably about 3 years ago or so in my practice is using data discovery and classification. And the idea is that every organization should have its own data classification system. So a system that says some data is safe for public, some is higher is protected in a higher way, and some is highly protected, i.e. Special personal data, for example. And so having a data classification system and then having an ability to go locate that data and identify it as such and make sure that all of your internal controls are working together to prevent that data from leaking or from being misused, et cetera, that's crucial. And so data discovery is its own discipline in many ways, and it's something that I really have found to be a huge help. Certainly, it made a big difference in my practice with clients, is making sure that they had a means to go locate everything on their network. And essentially, think of data classification, data discovery as a tool. It's an algorithm that will go through your network, identify data that's likely controlled in some way. It could be personal data, it could be ITAR controlled, which is something I dealt with in the past. It could be HIPAA data, it could be anything that is controlled and therefore needs to be identified and needs to be protected. So in a nutshell, your data inventory is your core document. You really can't have a GDPR compliance program without it. And just relying on interviews is just not going to do it. You really need an independent data discovery and classification system to be able to do that. So number two, determining whether you need a data protection officer. I think this is, if it's not the number one question, it's probably in the top three that I get. And this is Article 37. So appointing a data protection officer, it's every place I go, I get this question, Doug.
Why is there so much confusion about the appointment of a DPO?
For a couple reasons. One is that you'll find that people presume a data protection officer is just like another officer with a fancy title, like a chief privacy officer, for example. It's a senior officer, and they're part of the C-suite, and they're charged with important things, as it were. A DPO in this context is different. It's more like an ombudsman or someone that's an impartial party between the data protection authorities and the data subjects that the organization's data is processing. And so as a consequence, I think people just presume that everyone's going to have a DPO. And as a practical matter, I don't think you necessarily truly need one. In fact, I always recommend that people walk through really worst case scenarios. There are some organizations that a worst case scenario would be having medical information released into the public. That obviously is something that merits a DPO. There's 3 criteria for appointing a DPO, and the bar is pretty high. 2 of which are talking about the core activities of the controller or the processor in terms of regular and systematic monitoring of data subjects. So, for example, if you had some kind of a traffic cam, for example, and we're monitoring physical traffic, car traffic, or something like that, that's I think pretty easy that you would say, well, you know what, you're monitoring people, you can see them, their license plates as they go down the road. That's something that likely is going to need a DPO to make sure that there's not misuse of the data. So something that's regular and systematic is a great example. Or if you're processing special personal data on a large scale. So, for example, again, medical institutions, great example of that. They're almost by default going to have a DPO. If you are, say, a marketing company and you are crunching marketing data, and you've got data that could potentially be cross-referenced and it therefore becomes identifiable, even if it's been anonymized, potentially that's a great candidate for a DPO. And just really have to ask yourself, what's the worst case scenarios? If our data after we've processed it gets released in the public, how bad could the damage be? And that really is the driver. And I just think that people are going to wind up appointing DPOs unnecessarily. And if you appoint an internal person, it's really hard to get rid of them. Again, this is the model that the German DPOs used way back before the GDPR came on board. And I think that's the model that the GDPR folks, the folks that drafted it, had developed. So just in summary, I'd think twice about appointing a DPO. Really ask yourself, what's the worst case scenario? And then go from there. Yes, data protection by design and by default, that's Article 25. Also incorporates Article 32, which is information security.
So where did this idea come from, Scott?
I think, and this is just a guess based upon my cybersecurity background, is that there's this idea of a fail to safe mechanism in information security, where if something fails, it should fail to a safe state, so then it can't be exploited. And I think that this is the core concept that eventually became data protection by design and by default. I'm sure there's other folks out there that probably have come up with it independently of cybersecurity, but that's the idea. And you think about it, you want to design a system that has what we call this deterministic failure. So if it fails in a certain way, so it's not creating more exposure for privacy violations, it's creating less. So it's failing into a safe state. Again, same concept. And right now the challenge is, one, there's no generally accepted standards for data protection by design and by default. I mean, we certainly have those for software development life cycles and so forth, but just general GDPR style data processing, no generally accepted standards to work with. Also, we have a deadline. We have the May 25th deadline coming up, 2018, which is not that terribly far away. So the idea of retrofitting an existing or a legacy system for data protection by design and by default, just not going to happen. I mean, in many cases, it's a multi-year process, or it's just not doable. You would have to start from scratch, and people simply can't do that. So from my perspective, the resolution really are organizational controls, or administrative controls, however you want to articulate it. You think about all of the policies and procedures, running background checks on employees, privacy training, still the number one control in an organization, in my experience, is privacy training, making sure that people know what they can and can't do with personal data. All these kind of controls are so important, and I really recommend them for any organization that's on a tight deadline, is getting your policies and procedures written, getting them implemented. That includes your privacy policy, your privacy notices, and we're going to talk about that a little bit more in the broadcast. Your incident response plan, your breach notification plan, all of these are organizational controls, and there's a pretty big stack of them that needs to be done before the deadline May next year. And those really will go a very long way to minimizing your exposure for legacy systems, because there's just not time to rebuild or fix those systems. And certainly if you made changes, you may wind up breaking other things. So I'm very cognizant of that. I've certainly worked for enough software companies where you simply couldn't make those kind of changes in the short term. Yes, cross-border data transfers, which is Article 46 and a couple other articles, but this is one of the big ones. Get this question probably. This is my number 2 beyond DPOs.
You've mentioned in the past that there's a lot of confusion. Why is there so much confusion about cross-border transfers?
One reason is that there's an assumption that Privacy Shield is the same thing as GDPR. I've gotten that so many times I've stopped counting. That people presume that if they get Privacy Shield, then they're GDPR compliant, when in fact there's 99 articles in GDPR, and maybe 3 of them maybe 4 touch upon cross-border data transfers. So it's a fairly narrow area of compliance. And really, people, I think, still don't appreciate that you have 2 different hurdles you have to achieve or to overcome when you do processing of personal data. One is just getting a legitimate basis to process it in the first place. So getting someone's consent, for example. And the second is if you want to move it out of the EU, you have to find a legitimate means to do so. And so I really am a big fan of the 3 options we're seeing here. There's different reasons for them. So Privacy Shield is great for EU to US data transfers. So those one-way data transfers. So if you're a multinational and you want to transfer your employee data, for example, from your EU subsidiaries to, say, your system here in the US, say it's Workday or it's Oracle or what have you. Privacy Shield is a great solution. It's just a great general purpose solution, but it's only one way. It's from the EU to the US. That's it. You can't go from the EU to any other country. So that's the limitation of it. Versus standard contract clauses, which are nice, but they're part of a larger data processing addendum that you'll set up when you're working with an individual company. So I've written many of these things, and they're great on a one-by-one basis, but it becomes laborious after a while. If you have 100 third parties you're working with that are processing your data, and you've got to write 100 of these, it becomes very tedious and time-consuming. But if you want to go have the option of not having to deal with Privacy Shield and just doing this on a one-by-one basis, it's a good option. And then finally, binding corporate rules is also a great option now for processors, not just for data controllers. But I don't think that if people started today, they'd be able to even get binding corporate rules approved in time for the May 2018 deadline. So while I have a lot of admiration for them, I don't think it's a viable option at this moment. It's something that you probably want to start after the deadline and after you've got your basic compliance complete. Third-party compliance. Third-party compliance, yep, so this is a big part of my practice. This is Article 28.
In the past, you've mentioned that 40% of your time is spent on third-party compliance. Why is that?
Why is that? Because one is that when you do the data inventory, you'll start finding that many of your applications and processes are being processed or held or otherwise involve a third party. This could be a processor, it could be a business partner, it could be any number of things. But one of the things I found is that for every agreement you know you have, when you do the data inventory, you'll usually find 2 more that you don't know you have. In many cases, there's not a contract manager in an organization, and so every process owner has a copy of that contract, or they don't have a copy of the contract, but they know there's one floating around out there. So you spend a lot of time getting the contracts, finding out that many of them are years old. There's an MSA that you've signed in 2005 or something, and that you just kept extending it. And so there's no terms that even discuss data privacy. I've seen it all the time. So what I do typically is break this up into data third-party triage, essentially. So I have one group is the one-size-fits-all group. So these are the giant companies, the giant cloud-based companies. I won't mention any names here, but these are the ones that give you the data processing addendum I mentioned earlier and say, here you go, take it or leave it. So there's not a lot you can do with those folks. The second ones are what I call the team players. These are business partners that are willing to sign a data processing addendum, either with model contract clauses or some other kind of clauses to be able to become compliant with Article 28, which is a laundry list of things that processors need to do. And they're great to work with, and I highly recommend starting and working with those folks immediately to be able to at least get on their calendar and start resolving this. And then the third party in the triage is the laggards, and these are folks that either don't think they need to come into compliance with the GDPR. They actually disavow it. I've read contracts where they disavow any responsibility for personal data, which I think is fascinating. Or you have some that just can't come into compliance. They don't have the bandwidth to do all the work that's necessary. And so these folks, you really don't have, again, many options. It's going to be either informing them whether litigation is going to resolve their inability to fix things, either dropping the relationship altogether and going with another vendor, another third party, or offering some help to be able to get them compliant. So really, the third-party triage is a huge issue. It's also a big problem when you work with European Works Councils. In many cases, you're going to have to work with the Works Councils, get on their calendar, and they may just flat out veto whatever processing you're doing. They may not even know about it. They may get angry about it. I've dealt with all these things. And when that happens, then you really have issues. So getting on their calendar now is critical, especially since they tend to take the summer off. So that you need to get on the calendar and tell them what you're doing, especially if you're putting together a new privacy policy or other policies. In many cases, even if the policy doesn't affect them directly, they still get a vote on it, or they get to give you their opinion. And that can take a while. And if they don't like what you're doing, they can call the labor inspector. There's all kinds of political issues dealing with European Works Councils. So you really have to get on. Data protection impact assessments, DPIAs, this is Article 35.
A question to lead you into this topic. In the past, in past presentations, Scott, you've criticized the idea of DPIAs. Why is that?
That is because, as written, DPIAs are binary. Essentially, you ask, is it a high-risk application or process, or is it high risk to data subjects? The problem is that suppose it's not a high risk, but it's a medium risk. Then what? There's no DPIA that's necessary if it's, say, it's medium risk, but yet you have a medium level of risk, and therefore you have some risk that's higher than low, but it's not being addressed by a DPIA. I just disagree with how this was implemented. It was better to say, if something's a high risk activity, great, there's criteria that the Article 29 working group has put together. WP 248 gives a very nice list of criteria, about 10 different items, and in principle, if two or more apply, then strictly speaking, it's a high risk. But again, suppose that it's a medium risk. There's really no criteria for that, and you should be able to do a lower or simpler DPIA for medium risk items. So not thrilled with how they did it, but they did it, and this is what we have to work with. So as a practical matter, looking at the 248 guidelines and saying, okay, if there's two different qualities here or elements that are satisfied, in theory, it's high risk, but you really have to ask yourself, in many cases, what qualifies? For example, when something says, is the data processing involving automated decision-making that produces a significant effect on the data subject? What does that mean? So you have to go and dig in and find more commentary and more jurisprudence on just what qualifies as significant effect. So there's a lot more work that needs to be done in these areas, and there's just some of these criteria or a bit gray areas, if you will. So that's why I think you have a little more flexibility than simply saying yes, no, therefore it's a high risk determination. So again, just my opinion, but I take a holistic view. It's not something that's going to be very, again, binary, in spite of the fact that that's the way they've structured it. Okay, breach notification. That's Article 33.
Here's a question for you, Scott. Do most organizations have a breach notification program?
They do not. They do not. And this was surprising because most of the ones I work with have some species of incident response program. Certainly, if you're processing credit cards, if you're processing financial data, almost certainly you'll have some kind of incident response. But it's rare that I run into organizations that have a breach notification. Again, there's some that are exceptions, like medical institutions that have all gone through this many years ago. But by and large, vast majority of folks just don't have breach notification. And the big challenge they face is meeting the 72-hour deadline because or without undue delay for purposes of notifying data subjects. And the challenge here really is that most organizations just are not geared to meet that deadline. It's just not possible. In many cases here in the US, you've got 60 days to notify affected subjects. Here, 72 hours is just, I mean, in many cases, it's going to be insurmountable. So really the resolution is to set up a war room, is to get your folks from IT security, legal, HR, the application of the process owners, get them together and walk through worst case scenarios. What happens? And here's a great example is that say that you're company A and your competitor is company B, and company B gets hacked, and all of the personal data winds up on the internet. Anonymous breaks in or something. I mean, you can see it every day in the news. Really, the questions, the pressure is going to be on you now. Are you going to be the next victim? And so, as a practical matter, going through different scenarios that are likely, and saying, okay, we know what a competitor got hacked for and what bad guys are looking for. We need to think about the same thing and see how we would notify affected subjects, how we would notify the DPAs. Can we provide them with useful information? And where do you get the useful information? If you guessed a data inventory, you guessed correctly. This is why I'm such a huge fan of data inventories, because it's the single source of truth, if you will, for all the information that's being processed on your in your company, on your information ecosystem, and being able to provide useful information within 72 hours. So that if a data protection authority calls you, a supervisory authority calls you and says, okay, give me all the information, what was processed, did you have consent for it, how did you protect it, what are you doing to mitigate the damage, you'll already have all of those answers done ahead of time. And so it's one of those things that you really have to start practicing now and determining who's going to be involved in that process. So a breach notification, there's actually some fairly good documents out there already. NIST, which is National Institute of Standards and Technology, has something called Special Publication 800-61, and talks about breach notification and breach response. It's something that, talks about incident response, but it's a great tool to be able to use for your incident response program and then build your breach notification program on top of that. Notice and consent. So two sets of articles. One is 12 through 14, and then the rest are articles 7 and 8.
Is there an easy way to develop ideas for the content of the notice?
There is. There's two different ways. One is that you can simply use a checklist method, go into the articles themselves on the notice part, and there's just a laundry list of things that you can draw from. So that's one way. The other way is to look at GAPP. That's generally accepted privacy principles, and you can just Google that and find that it's very easy. It's done by the American Society of CPAs and Canadian Society of CPAs. It's a great document. Used it in the past in many occasions. And there's a transparency element in GAPP, and there's great questions there and great elements there for putting on a privacy notice. And so I would really draw both from GDPR and from the GAPP document, and use that to fill out the content of the notice. And I tend to make it very rote, so that if a third party is looking at your notice, they can just check items off. Say, yeah, they've covered that, they've covered that, they've covered that. Because in most cases, what you're going to find is the things that are missing are just pre-GDPR requirements. So, or said a different way, their notices are pre-GDPR notices, so they don't have some of the requirements, like, for example, notifying how to revoke consent if your processing is based on consent. There's really no, typically that's not covered in privacy notices when it needs to be. Also, the idea of telling someone that a DPA is their final route, if you will, if they can find, if there's a dispute and they can't get satisfaction by working with the data controller, they can go to the DPA. And that's not typically on a privacy notice, and it's something that should be on there. So you can get a really good list of information, both from GAPP transparency requirements and then from the articles themselves. So that's one component. The other component is notice availability. In many cases, there'll be a notice that'll be on the website, and that's it. And I think a lot of organizations rely on that notice. And really where the notice has to be is at every point that you're collecting information. So this, in many cases, is going to require someone to put, a data controller to put either a checkbox and a notice at the point where they're actually asking for the data, not just relying on something at the bottom of their website, for example. And you may be collecting collecting information at different points on the website, and you're going to have to put a link to that notice at every point. So this is, again, you go back to your data inventory and ask yourself, what data are you collecting? How are you providing notice to the data subjects that you're collecting it. If you're relying on consent, then obviously you need a consent mechanism to be able to track and to be able to produce a report that says, yep, we got consent from this data subject or that data subject. So that's really the challenge. And so your data inventory is again, a great mechanism for finding all those answers. And by doing all that hard work up front, then you're able to get an idea of exactly what kind of, where to put the notice, at what instances the notice has to be placed, and covering all the different scenarios where someone's going to want notice, and in some cases, if they have to provide consent, be able to provide consent at that point. So that's again the value of the data inventory. Right to erasure, also known as right to be forgotten, and this is Article 17 of the GDPR.
So what's the biggest misunderstanding about the right to be forgotten?
I think that the biggest misunderstanding is that if a data subject sends you a request to be forgotten, that you have to obliterate every electron in your organization that references or contains their personal data. And that's just not the case. There's a baked-in reasonableness requirement. And let's talk a little bit about how this came into being. There was a gentleman in Spain that went through some financial difficulties, and that, for whatever reason, wound up in a local newspaper. Google linked to that, indexed that, and so everyone essentially knew about this, and the poor guy suffered as a consequence for years after this story came out. And so he asked Google to remove the link. They said no. He asked the Spanish DPA to force Google, and they did. And so that became the right to be forgotten, essentially, and now it's embodied as the right to erasure. So that's how it came out. So you can see in that context that there's no need really to keep that link there, and as a consequence, there's no issue with eliminating it. So contrast that to what some people seem to think is that, well, if someone sends me a requirement to be forgotten, then that's it. Search and destroy mission in my organization. I have to just get rid of every electron that mentions them. Not true. Okay, so say that you're paying a former employee a pension, or you're going to pay them 25 years this pension. You wouldn't want to destroy that information because it would harm the data subject. So a great example, or if there's other benefits that you're doing, or perhaps you want to provide, and you're legally allowed to provide a reference to that person. If you destroy any records of that person being there, you're not going to be able to provide a reference for them. So there's all kinds of reasons why you would not necessarily want to eliminate something. So you really have to use some common sense here and some reason and say, would eliminating this data harm or potentially harm the data subject, or would it harm other data subjects? Again, a lot of the databases that we have here are very brittle, and if you do make some changes to one piece, it can potentially break other pieces. So you have to ask, if I remove this data, will it harm someone else? Or will it harm the organization? Is the effort we have to do disproportionate? I mean, there's all kinds of reasonableness that's baked into this. And being able to prepare a memo ahead of time saying, here are the processes, again, go back to data inventory, here are the processes, and here's the data that we're processing. Here's what we're willing to eliminate as a function of right to be forgotten. Here's what we're not, and here's the legal basis for that, because we're going to harm the data subject, we're going to harm others or harm the organization. Being able to provide that, so that if you get that inquiry or a supervisory authority asks you, why are you not deleting this information, you have a very succinct answer. So it's very interesting. Again, a question I get with some regularity: go through worst case scenarios, get an idea. Here's a great worst case scenario. Again, as a competitor gets hacked and people realize, hey, I go with your company, competitor just got hacked, all their data wound up on the internet. I want to know, what do you got on me? I get that question all the time. What do you got on me? Well, what you got, as the case may be, depends on what your data is being collected. You'll go to that inventory and get an idea. And then from there on out, do scenarios. If we got 100 of these requests, could we even do a right to be forgotten on all these people? Or would it create utter chaos in the organization? I think there's a lot of folks that are not going to realize just how much work this is going to be until they get hit with these requests, and they're going to be behind the 8 ball at that point. So again, this is just really militates for building up scenarios ahead of time, referring to your data inventory, and making sure that you can address all these different things. Crafting a privacy policy, which is implied under Article 32.
What's the difference between a privacy policy and a privacy notice?
Privacy notice is telling the public, or data subjects, if you will, but the public really, what you're doing with personal data, how you're processing it. privacy policy is an internal document, and it's really a guidance document on, at a very high level, if you will, on what your posture is, how you respect personal data, your commitment to protecting personal data, and most importantly, if you don't follow the regulations that the company puts out, you can be disciplined. This is key. There's a lot of confusion because people presume that a privacy policy and a privacy notice are the same thing. They are not. If you can't be punished for doing something wrong vis-a-vis privacy, it's not a policy, it's just happy thoughts. And I, again, see this all the time. People have privacy notices, don't have a privacy policy. So there's no guiding document in an organization to be able to show people how they should protect personal data. There's nothing there to mandate privacy training, which, as I mentioned earlier, is your best line of defense against privacy and security violations. So really, a lot of people ask me, well, where is this in the GDPR? It's nowhere. Okay, Article 32 implies that you have to have a privacy policy because you have to have technical and organizational or administrative controls. And a policy and a procedure and a plan, all those things are controls. And they're administrative or organizational controls, and really you need to have them, otherwise no one can be punished for doing something wrong, and it's hard to have any kind of ability to manage your company's personal data that you're processing without that kind of policy. So here on the screen, you're seeing I have a very simplified table of contents, if you will, and it just goes through, cites the company's commitment to protecting personal data. It'll give the scope of what kind of personal data is being addressed. It'll give principles, and again, principles, you can go right to GAPP, great principles for processing personal data. There's no reason to reinvent the wheel, they're already there. Talk about how you're going to be transferring personal information to personal data to different business units in your organization, and how you're going to do it with third parties. What's your overall policy? You're going to mandate that third parties have a data protection policy and practices and security and all those things that come under Article 28. So really, you're going to be using this document, this privacy policy, as a top-level document. And then you'll have appended to it all kinds of things, perhaps your breach notification plan, perhaps other plans or other procedures, or you'll have references in your appendix to other plans and procedures and notices and what have you. You may have a data classification committee, which is something I very much recommend for every organization, to be able to determine how data is going to be classified and how the classification is going to be enforced. I see all kinds of paper data classification systems. The problem is they don't work because there's no mechanism to enforce them. There is no way to say, oh, this is personal data, don't email it, don't attach it to an email, or don't allow these persons to have it, or only allow these persons to have it, etc. So a privacy policy is that master document. It's something that every organization has to have. I don't see how you can function without one because there's no direction, there's no guidance.
Great. Well, thank you, Scott. What I'd like to do now for the remainder of the time is go over the questions. Are there any existing certifications for total GDPR compliance?
No. Not only are there no certifications, there's not even an audit program. So, and I'll give you a counterexample. NIST 800-53 has 853A, which is your audit program. So there's nothing like this at this point. So as a practical matter, when I am on client engagements, spend a lot of time looking at the implicated controls that an article will have, and asking myself, well, how would I address that? Either using a NIST document or perhaps using the GAPP document, GAPP guidelines documents, and then creating controls out of that. So that's really how I do it, and it's been very successful, and I think that that's what we're going to have to do until we get some kind of guidelines or audit plans from the European authorities.
Got it. This appears to be a related question, but I'll just, it comes from the same person. I'll just ask it as it's written. Have they any kind of problems? I know that ISO 27001 doesn't cover all data subject rights aspects.
That's true, it doesn't. I have to remember that I'm a big fan of ISO 27K, by the way, so don't think that I'm being negative about it. It's an information security certification and controls plan, and it's a great one. But remember, there's only one section that talks about information security in GDPR, and that's Article 32. Now, it's implicated elsewhere, like in data protection, impact assessments and so forth, and data privacy, data protection by design, by default, et cetera, et cetera. But as a practical matter, that's just one. So even if you're ISO 27K certified, don't presume that that means that you're okay with GDPR. So much of GDPR is about what you're doing with the data you've already legitimately collected. So in that case, 27K is not going to help you there. Also, you have to look at the SOA on ISO 27K. So what areas are even being covered? It may be that the processing you're doing is not even covered under your SOA for ISO 27K. I'm sorry, your statement of applicability, my apologies. So that's an issue as well. So it's great insofar as it goes, but it's not going to by itself get you there.
Great. Next question is regarding the breach notification. Is the breach notification time frame 72 clock hours?
Oh, as opposed to business hours? Good question. I'm presuming it is 72 clock hours. Yes, absolutely, which I know sounds insane, but keep in mind that now defense contractors and government contractors are going to have to meet that same standard by the end of the year as well. So evidently this is catching on as a practical matter. So yes, presume it's 72 clock hours, not 72 business hours.
So another question is, how should a data processor approach data inventory?
Same way that a data controller would, is look at the different kind of data you're processing and ask all the same hard questions. Who's responsible for this particular process, or who's and there may be one person that's ultimately responsible, but many people that work under him or her. So find all the people that are responsible that can answer questions. You're going to have to find out where that information is in your organization, which again begs the question about doing data discovery and classification and making sure that you know where everything is. And I've said this umpteen times, so forgive me if you've heard me say this before, those of you on the webcast, but it's so important to realize that in most cases, when you have data stolen from your organization, it's data you didn't even know was on your own network. So do the same things that you would do as a data controller for conducting a data inventory. Go through, look at all your processes, find out who's responsible, how you're protecting it, and if you had to answer questions within 72 hours, could you do it? Because you know your data controller is going to be asking the same thing for you, because you're held to the same standard as your data controller is for all intents and purposes.
Great. Related question, is it sufficient to know where the data is, how it moves, and the data elements that are being held?
It's not sufficient, okay? And I'll give you a great example. Who else has access to it? Is it a third party? Suppose that your third party has other parties that have access to that, so fourth parties. You have to know all those things because that's all downstream. And in many cases, again, your third parties are going to want to have sub-processors, which is fine, but you have to know about those sub-processors and ask, are they being held to the same standards? Everyone has to be held to the same standards in the chain, otherwise there's no point. You could have the weakest link in the chain being a fourth party who is, you've never even heard of these people, you don't know where they are, and as a consequence, if a breach happens, you're not going to know who to contact, and that's got to be on your data inventory. So there's much more. I probably have 30 or 40 fields in my data inventory for each data process. So that'll just give you a good example of that.
Okay, great. A couple other questions, and then we'll wrap up. Does the GDPR pertain to EU citizens or EU residents? For example, if I'm an EU citizen living outside of the EU, is my data protected? And if I'm a non-EU citizen living in the EU, is my data protected?
If I'm inside the EU borders, I'm protected. So as an American citizen, if I go over there and go to a hotel, for example, the data they process on my behalf for my hotel stay, that's covered under the GDPR, and it's presumably even covered currently in the Data Protection Directive. As far as EU residents outside of the country, that's an open question. You can make an argument that once they leave the borders and they create new data, here say they visit the US, you can make a great argument that GDPR does not apply to them for data created here in the US. Now here's the problem. Suppose you're processing that data on a server that's in the EU, then you're out of luck. Okay, now the server's in the EU, the data is being processed there. or a third party in the EU is processing that data, then guess what? You're back into GDPR. So it's as a practical matter, it's tough to escape.
Great. This looks like the final question. What is the enforcement body for fines, and how does it apply to companies that are only U.S. based?
Well, if you're only U.S. based, as a practical matter, the Data Protection Authority in the EU would have to go to, say, the FTC to be able to get some kind of enforcement. So say that you're U.S. based only and you're studying the behavior of EU citizens. Maybe you're a data analytics company and you've bought data from third parties and you're crunching it and looking at buying patterns and what they may be interested in buying and so forth. If someone finds out that you've done that and that you're processing that data, potentially they can complain to the Data Protection Authority, who would then go to the FTC, who regulates data protection here in the U.S., and potentially even go to the state's attorneys general in which that company operates and say, hey, they're doing something wrong here. Would you investigate? And then ask them to open an investigation. I can't guarantee that the FTC would do so, but they seem very willing to, in the past, to do so. And you think about when Google got into trouble a couple years ago for capturing information from access points, wireless access points, they got fined in the EU. They also got fined in the US as well by the FTC. So would not be surprised if that was the case.
Well, great. It appears that there are no more questions. We'll go ahead and wrap this up. Again, thank you, everybody, for joining us today. We'll send you a copy of the presentation, a link to the recording. And if you have any further questions, feel free to reach out to Scott directly. We'll include his contact information in the email. Scott, perhaps if you could share your email address, people can send.
Sure. Very simple. It's scott.giordano@roberthalflegal.com, and that'll be on the presentation as well. So you'll be able to have that once we send that to you.
Well, thank you again for joining us, and thank you for the information, Scott. And everybody have a great day.
You're most welcome. Bye-bye.